All right. Happy Friday Eve, everybody. So I know that it is currently not 9 o'clock, but if you all are ready to proceed with your matter on Mr. Richard Baker, we can proceed.
Ready as well, Your Honor. We'll invoke the rule.
All right. So are there any witnesses that are going to testify?
They're just going to give victim impact statements. It's not necessarily.
All right. Yes.
Baker, please come forward.
Sure.
You have just 1 minute. So there is an issue of restitution on the one that they approve.
Because there's no other witnesses.
All right. So do you have any objection? Are you going to have any objection to them staying in if they're just going to be testifying to restitution?
None, Your Honor.
Okay. There's that.
Thanks, Judge.
All right. Are you ready, Cindy? Yes. Court is calling 2025 CR 012469 and 2024 CR 01259, State versus Richard Nelton Baker. Can I have parties announced for the record?
Granted for the state of Texas.
Pat Montgomery for Richard Baker.
And are you Mr. Baker? All right, you entered a plea and cause number 2024 CR 012590 of no contest to the offense of aggravated assault with a deadly weapon. And you also entered a plea of no contest to count 1 and cause number 2024 CR 012469 for the offense of assault family household member with a previous conviction. There was a PSI and TAP evaluation ordered. Have both parties had a chance to review the PSI and TAP evaluation?
We have, Your Honor.
Any objections?
None, Judge.
All right. And the cause numbers, the defense has applied for deferred adjudication. Defense, do you have any witnesses?
I do, Your Honor. Mr. Baker wishes to address the court. I'll call him as a witness.
All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Sure.
All right, you can lower your hand, state your name for the record. All right, defense, you may proceed.
Mr. Baker, are you a veteran of the U.S. military?
Yes, sir.
How long did you serve?
16 years.
16 years.
Yes.
You have any service-connected disability?
PTSD,
What is the cause of your PTSD?
overseas in Afghanistan and Iraq.
Did-
I have to at school, I take my test alone, reading, then concentration, standing on my left leg, I have surgery on my left leg also.
Do you have psychiatric
Yeah,
issues
I do.
other than the
Yeah.
PTSD?
Yes, sir.
What are those?
Being around certain people, guns, and being compensated.
Do you suffer from hypervigilance?
Yes.
Have you struggled with any kind of substance abuse?
No, sir.
During your time since you've separated from the service, have you continued to seek treatment from the Veterans Administration?
Yes, at the psych ward at the VA, it's every 6 months.
Other than those twice a year,
Lots of medicine.
what kinds of medicines are you on?
Sertraline, topromat, posine, trazodone. Stuff for high blood pressure.
Does the trazodone help with your hypervigilance?
Yes, yes,
You realize why you're here today?
yes, sir.
We're asking the judge to place you on some kind of community supervision, correct?
Yes, sir.
Do you know that if she does sentence you to some kind of community supervision, you'll be required to report to probation?
Yes, sir.
You'll may be required to do some time in an inpatient treatment program to make sure that you're safe from yourself and folks in the community are safe.
Yes, as long as I get the help.
Is that what you're
Yes.
seeking? Do you feel like the Veterans Administration, despite their best efforts, has not been giving you the help that maybe you could
I can
benefit
use a little
from?
bit more.
You could use some more.
Yes.
And so what specifically is your request of Judge Floyd?
Turn to anger management. And for probation.
And do you understand that if you take deferred adjudication probation and you violate it, you can be sent to prison for 20 years and you would have to do half of that time before you would even be allowed to ask to
Yes,
get
sir.
out early.
Yes, sir.
And that doesn't mean you would get out early. Ask the witness, Judge.
Any questions?
Serving in the military?
Yes, sir.
Thank you for your service.
Thank
Now you've mentioned that you have suffered from issues since being released from the military.
Yes, sir.
The medication that you were talking about that you would have to take to help you with your issues, were you taking it on the day
No,
of
sir.
the offenses?
No, I did not have a prescription refilled at the time.
Why is that?
The VA is backed up because the certain type is a narcotic. Prazosin, and it takes about a week. And I just ordered it 2 days prior to the incident.
Okay.
And I didn't have transportation to get to the VA to get the medicine.
Now, if you mentioned that you have issues with weapons, why was a weapon involved in one of your charges?
That was an incident I should not have grabbed. That was a mistake of mine. That was the household weapon.
How were you mistaken?
I should not have grabbed. That was when I saw what had happened. I overreacted, and it was like I was back over in Iraq.
Okay, so you felt that firing the weapon into
Yes.
the vehicle was a bad decision? Is that what you're
Yes,
saying?
sir. Exactly.
I have no further questions, Ron.
No more questions, Judge.
All right, I have questions if there's no,
No objection, Judge. He did want allocution, so conferring with the court is a great idea.
all right. So you've been on probation before
Yes, ma'am.
for assault, bodily injury, family household.
Yes, ma'am.
And you're telling me that at that time you didn't gain control of your anger?
I took the anger management class with Mr. DeSoto, and I learned. Actually, he recommended me to nursing school.
All right, that was 2018.
Okay. When I started school in 2000, 2 years ago, we still keep in contact, and I still take my medicine. But at the time, I was not taking it because I was worried about school.
So you're worried about school, so that's why you're not taking.
No, I did not have the medicine at that time because
Mhm.
at the time the VA was backlogged.
All right. And then any objections to the court reviewing the PSI report?
None, Judge.
All right. So then my other question is, in the PSI report, tell me what's going on with you and your mother?
Well, I have issues with my brother actually.
No.
Okay.
That's not my question.
Nothing with my mom.
All right. So why were there items of hers that were pawned? Did she give you permission to pawn her wedding?
Yes.
So she gave you permission to pawn her wedding ring. She gave you permission.
I
Hmm?
also let her have. She's on my account at the bank. I told her to get everything out.
I'm sorry, you
I
what?
told her to get everything out using my account. She's on my account.
So wait a minute though. So you're telling the court that she told you to pawn all the televisions in the house and that she told you to pawn her wedding ring
And my computer.
and her lamp.
Yeah.
And you were not, because they're saying that you were using drugs.
No, ma'am. I've never had an issue with drugs.
Then I don't understand your issue then, because you've been given chances with anger management.
The money was used for bills, ma'am. because I was not working at school. I'm work program study. And I'm 100% disabled with the military.
Your brother says that you have a drug problem. And then this is what is said in here. It says, my son Patrick was in another place, and later I found out he was doing things that were contrary to our belief system. He stole money from my pension, and I gradually found a way to do things by having Patrick come live with me. Then I was able to see a part of what Ricky was doing. He was having women come over. They were supposed to be college studies, but he wasn't. This broke my heart. We later found out that he was on drugs and he assaulted Patrick, and he had just had surgery on his foot. He attacked Patrick and scared me to death. I told Patrick to leave him alone because he already had his foot in a boot. When this was over, Ricky had been hit, but he was the aggressor. Patrick was trying to do the right thing. When Ricky hit Patrick, it was right in the abdomen, and he was in pain for 2 weeks or so. That instigated the police to come. Ricky was laissez-faire about everything. He writes letters all the time. I'm positive he wants people to say nice things about him. Ricky is not telling people to write letters to, Ricky is now telling people to write letters to his mom to tell me to quit talking to the DA's office. He writes 6 letters per day and tells Patrick to quit talking to the DA's office. I love my son. I love both my sons. I was raised by a good family. I would rather Ricky stay in prison for a while to learn what he has done. He is a good man, but he has gone crazy, in my opinion. He has also attacked me after my husband died, and I was not treated as a mother for a long while. I was verbally abused, called stupid, and the C word. That's just not what he was raised to do. I don't love the fact that my son is going to prison, but Lord, please put him in prison for a while. There have been times that he has pushed me down and put both hands on my shoulders and pushed me. He has a drug habit. I don't want to lose him. I'm 85 and I really love my children, but the best thing is to get him treatment in a good place where he can go to work, like food or mechanical jobs. Just don't put him in prison to do nothing. We want to support him, but I would rather he be in jail with support. And if that doesn't work, I don't know what to do. He needs to be there, and he needs to have something to do there. And we will go see him on a monthly basis. I gradually realized he is using me. And then Patrick says, I'm not asking for any restitution. I didn't have any medical bills. All I ask for is for him to act right. He can't smoke dope all day and steal from our mom. So here's the thing. I believe what your mom's saying. I believe you were abusive to her. So are you saying you were not abusive to her? You didn't push her down?
Hit one time, that's when I hit the last case.
All right.
In 2000, I put my hands on her.
So yeah.
Yeah,
And
that
you,
was
and
the
how
last
old are
time.
you? How old are you?
51.
You shouldn't be living with your mom anyway. And then I do believe that you were pawning her stuff without her permission. And let me ask you something. Did she love your dad? All right, so there's no way if she loved your dad that she would be asking you to pawn her rings. And the only reason why she got some of her items back is because the neighbor said that they recognized that as hers and they bought them back from the pawn shop for her. So here you are in your mom's home, being abusive to her. She's afraid of you. And you're using PTSD as an excuse
Yes.
to run amok and not do anything. And then this thing with the Lyft driver is not good either. And let me see where that is. Victim stated he is a Lyft driver and was dispatched to pick up victim 2. Victim stated he was driving to the pickup location, your address. He received a message from victim 2 stating for victim 1 to hurry because victim 2 was in danger from you. Victim one stated victim two got into victim one's listed vehicle to depart the pickup location. Victim stated as they were driving away, suspect, that's you, caught up with victim, cut them off. And then when they're driving away, you're firing into their vehicle. They could have died. And then he's not supposed to have a weapon because of that previous family violence case. So why do you have a weapon anyway?
House.
Yeah, that's not supposed to be. So I'm not going to grant his motion. Do you have restitution hearing? I mean,
Yes. On the other case for the restitution, he's a bit to lift.
all right, let's hear the hearing on restitution. In each case, I'm going to find you guilty. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand, state your name for the record.
Hello, Laquel Calloway.
All right, so my understanding from the state is there may be some restitution issues. Is that correct, state?
Sure.
All right, you may question the witness regarding restitution.
Mr. Cowell?
Good morning.
Now, this incident resulted in damage to the vehicle that you were driving that vehicle.
Yes, sir.
Was that your personal vehicle or was it a business vehicle?
My personal vehicle.
And what happened after the damage was done to your vehicle? Did you try and get it fixed?
I tried to get it fixed at a body shop and Uber would not cover it, nor State Farm. I originally had State Farm insurance. It won't cover it because of the nature of the incident. And then two, Uber does have coverage, but Uber will only cover after after $2,500. So basically I had to come out of pocket.
Okay.
And I had to replace the windshield speakers.
Okay, let's take this one at a time.
Yes, sir. Sorry.
Where'd you go to get your vehicle fixed?
I went to Caliber Collision on Austin Highway Center.
Okay, did you meet with someone there about the damage to your vehicle?
Yes,
Okay, did he, along with you, inspect the vehicle for the damage?
yes, sir.
What type of damage was done to your vehicle after you left?
And the type of damage that was done was it was shot up on the back by the gas tank. Bullets went through my seats and headrest, almost hit my head. Bullets also hit the dash, and several bullets went through the windshields.
Okay, and did you talk about what it would cost to have damage to your vehicle fixed?
Yes.
Okay, and they tell you at the time to get your vehicle fixed?
Yes.
Did you an estimate for how much it would cost you?
Yes.
And did you review that estimate with them?
Yes, sir.
What was the amount that was decided to do as far as the total damage to your vehicle fixed?
Total damage, so it's, and I just calculated, there's 2,900 plus 600 for the front of the windshields. About 3,500.
Pay for all that to get your vehicle fixed?
Yes, I had to get a loan from rental.
Okay, so you had to pay it out of your own pocket for that?
Yes.
Okay. Is the vehicle now repaired?
No, I had to surrender it.
Why
It was officially repaired, but I had to surrender because I could.
Okay, but the mechanical problems were fixed, correct?
Yes.
Okay. Did you incur any other expenses as a result of this incident?
Yes, I had to surrender my vehicle because I couldn't pay it no more. That was how I was making my share. I lost my job with Uber because of the incident of the shooting. The fact that it was a shooting involved. And then I couldn't afford the loan that I used to try to get the van out of the shop because again, that was what I needed to make money. I lost my nursing school program. I was in the BSN program for registered nursing. And I lost that because that's how I was paying for tuition. Yeah, it's a domino effect. I lost everything.
Have you incurred any additional expenses beyond?
Yes, I incurred for my medication that I now have to take. I've also incurred debt because of the vehicle and the loan I couldn't pay. And
Anything else?
it's pretty much other than my tuition debt.
I'm not really putting this on past this.
You said you borrowed $3,500.
No, that's the total.
Oh, okay.
Yeah.
But you paid a approximately or right at about $3,500 for the repairs to the vehicle, am I
Yes, sir.
correct?
Uh-huh.
And all of that $3,500 went to the repairs to the vehicle, right?
Yes.
No questions, Judge.
All right.
Yeah.
So, any
Motion to-
further questions?
I'm just gonna tender this to defense and enter into evidence too, if he has an objection.
No objection, Judge. I've already looked at it. It basically serves to show you the damages to the vehicle.
All right, sir, what I can tell you is there are some amounts of restitution that I'm allowed to order, and then there are some I'm not allowed to order. The restitution to your vehicle, I'm allowed to give you that. But everything that happened because of that, that's more of a civil matter. So you're being out of work. I'm not allowed to give you restitution for whatever you would have made if you would have been able to work as an Uber driver or had your car. But I am allowed to give you the money for the vehicle and what's related to this case directly. Okay. Is there anything else? All right, thank you. Thank you for coming down twice. All right, this is what the court is going to do. And 2024 CR 012590, court is finding you guilty. The court is going to sentence you to 6 years in the prison. There's an affirmative finding of deadly weapon. This is run concurrent with 2024 CR 012469. There's to be no contact with LaCale Calloway. There's to be restitution of $3,500 to LaCale Calloway. I'll order the therapeutic community to help you with whatever issues you say you have. And 2024 CR 012469, the court is finding you guilty. The court will sentence you to 6 years in the prison, give you credit for any time served. There's a $1,500 fine. This is run concurrent with 2024 CR 012590. Take in consideration 2024 CC 740803. There's an affirmative finding of family violence. There's to be no contact with Patrick Baker, Jerry Baker, or on to order the therapeutic community. So you're not allowed to have any contact with any of those people I mentioned. You're not allowed to have any more contact with your mother. You're not allowed to have any contact with your brother. If for some reason they want to have contact with you, then they'll need to file the proper cases or the proper motions to have that happen. But I'm not allowing the contact. In each case, did you review the documents entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? Because these are, yes or no?
Yes, ma'am.
Because these are plea bargain agreements, because I followed your plea bargain agreement, because you waived your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions, and because in cause number 2024 CR 012469, there's an affirmative finding of family violence. You're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the
May I
thing.
address the court
Yes.
before we go off the record?
All right, we're on the record. Yes.
I would ask that any monies that he pays once he is out on parole or once he discharges his sentence, that monies that he pays goes to the restitution. But I know how the parole board will be. They'll put some of that money to the fine the court assessed. I'd ask the court to reconsider the fines on the cases, zero those fines out so that Mr. Baker, as a disabled veteran, can pay with his disability checks that he's not getting while incarcerated, can pay back the complainant in the case.
I'll make an, I'm not going to zero out the fines, but I'll make an order that the court is requesting that in cause number 2024 CR 012590, that restitution takes precedent over all fine and fees.
Thank you.
All right, we can go off the record. Here's the thing. I understand mental health, but you can't use your mental health as excuses to be violent towards people. You previously received help for that, and I guess, you didn't follow through. And you're saying that you don't have a drug problem, but your mom and your brother are saying you have a drug problem. Anytime you push your mom, hit your mom, sell her items, that tells me you have a drug problem. So you're going to have to look internally with yourself and find out what is going on with you and why you're doing what you're doing to your family. You understand? All right. When you're released from prison, if you can't find a place to go to get help, if I'm still here, you can come here. I'll find a placement for you. All right. Good luck to you. All right. Victim impact, please.
Back against the counter. You don't say anything.
Yes, you may proceed.
Raquel Calloway. The first few days after my attempted murder on August 3rd, 2023, I spent sleepless and stressed. During this time, I felt a range of emotions, but I mostly felt helpless during this period. Anxiety triggers a fight or flight response, releasing stress hormones like cortisol and adrenaline. These hormones can increase stomach acid, leading to acid reflux and ulcers, tighten stomach muscles, causing cramping and pain, slow digestion, leading to bloating and constipation, all of which I experienced 3 times due to having ulcerative colitis. During the long hours and days at my BSN program and work, my thoughts continually drifted to Baker and the prostitute. As the hours turned into days, the question arose how I was going to pay for my registered nursing education. I had already started clinicals and was in scrubs. I even passed full body assessments, which is difficult without any paperwork and going off of memory only. Considering my mind was clouded and distracted with trauma due to not having a vehicle to perform rideshare, I had to withdraw from the program. Not because I failed, because I passed my courses, I just couldn't any longer afford it because as the months pass, I haven't healed. The scars I will carry are a reminder of how close I came to death and graduation. The emotional roller coaster is never ending. I held anger at a man and woman who was freely walking the streets, who I believe had no conscience for attempting to take my life when he chose to shoot at me. They both showed no remorse as the prostitute tried getting away with comments such as my son has a disability and I have one for Winchester Police Department before she was arrested. Baker having the nerve to call the cops pretending to play victim, thinking I was dead. Here I am denied opportunity to continue my college education and election nursing for the winter quarter to be able to focus at work, to ride or drive a car without riding. My family has witnessed and continued their ongoing mental pain and struggle with my emotions. As I waited for the legal process to unfold, I took time off of work to attend today and the day before. Preparing to go to trial, the roller coaster of emotions continue. Every day I feel frustration that the man and the prostitute who did this to me and continue to escape the legal ramifications I hope will befall them. When I arrived at the body shop, I was stunned at the appearance of the van that clearly showed how blessed I was to be alive. It remains a mystery how Baker and the prostitute walked away unscathed after seeing how mangled the van was at me and the prostitute right now. It seems the dawning of a new year will never hold the same promise for me. The settlement for possibilities of the coming year, I'm experiencing anxiety, frightful memories, and anger. I only hope that with each passing year, the meaning of the bright new year will hold more than painful memories. I've been diagnosed with depression, anxiety, as well as post-traumatic stress disorder. I've even taken classes in HCL for nightmares. I can't see the words and stuff. That's good. I also think I can afford to pay it without doing rideshare, so I had to surrender it. None of this would have happened or occurred if the prosecutor didn't decide to use Uber and call 911 instead. She was also at great fault with Baker, and she received more than a misdemeanor for my attempted murder. Now, over a year later, I asked this court to consider the magnitude and impact of the crime this on my body and my family and my daughters. I'm seeking and requesting that, of course, sorry. He wasn't supposed to be around any firearms. He also has a history of committing crimes. I witnessed that myself on the internet. And lastly, I would ask your honor to consider sending Mr. Baker to the maximum sentence under the law, as any time spent incarcerated is nothing compared to what he and the prostitute has caused myself and my family will experience for a lifetime. Thank you for allowing me.
Thank you.
And Judge,
Yes,
you had previously stated that you would allow the
yes.
victim's
Who's,
father to make a short statement.
yes.
How you doing, Judge?
Hello.
My name is Mr. John L. Calloway Jr. I'm the kid's daddy. He caused a lot of pain to my son for no reason at all. My son is a good son. He is a good person. And then him using the excuse that he has problems. Well, if you had problems, you should have went and got treated for those problems. And I'm like this, restitution, it should be $20,000. And 6 years in the pen should be 10 years. He almost killed my son. You know what that's like to be shot at with a gun? For you to just be doing your job, like if I'm sitting right here, and then someone comes in, bam. You know how scary that is? Do anybody know how scary that is? Well, I tell you what, if it was me,
All right, so sir. No, here's the thing. So this is what I tell everybody when they're giving victim impact statements. I understand, I do. The anger that people feel because that's your son. I understand that your son's life could have easily ended that day, not because he was doing something wrong, but because of the actions of someone else.
yes,
But
ma'am.
this is what I've discovered in my time in this world and on this planet. I've been a defense attorney and I've been a prosecutor. And do you know the most touching victim impact statements that I've heard that will really be impactful is when people keep the tone right here, don't show anger, and just talk to people. Because what I've discovered is when people talk very loud and they're shouting, everybody just shut down and close off because they feel, okay, they're shouting at me, they're angry, I'm not even going to listen to this. So that's what I impart to you.
Yes, ma'am.
So what I suggest you do, bring your tone down to here, right? Because you're angry, you're upset because your son life was put in danger. And all that he's worked for, he's on a different path now because there was a domino effect based upon what happened to him.
Yes, ma'am.
So gonna need you to lower the tone,
Yes, ma'am.
all right?
Yes, ma'am.
And what I can tell you is sometimes the state and the defense will reach plea bargain agreements. And there are a host of reasons why they reach those plea bargain agreements. My job as a judge is to look at that and make a decision on whether or not it's appropriate. The plea agreement in this case was a cap of 6 years in the prison. So what does that mean? That means that the court could sentence him anywhere from 6 to 2 years. That's it. Otherwise, there would be a jury trial. And we have a lot of trials in this courtroom. We're currently in a capital murder trial.
Yes, ma'am.
And we have back-to-back trials. So this trial would have taken place at a much later date. So I want to ask you, take a deep breath, as they say, woosah,
Yes, ma'am.
and then just speak in a tone where people will have their ears open to listen.
Yes, ma'am.
Now, so if you want to tell him, hey, you impacted my life because this is my son, I love my son, and parents should not be outliving their children, especially due to acts of violence. If you want to tell him that, then tell him that, but keep it level, okay?
So you said I can talk directly to him?
Yes, but
Yes, ma'am.
let's all be respectful.
I'll stay calm. Yes,
All
ma'am.
right.
Excuse me, sir.
My apologies.
You was in the service, right?
Yeah.
I was too. I'm an ex-Marine. I'm a trained government killer. And I'll be having problems just like anybody else. But I don't go around putting guns at people and shooting at people no matter what. I mean, I understand that the prostitute, she messed up and she made you angry. But there's better ways, my brother. You need real help. You need spiritual help. Somebody needs to give you a Holy Bible when you go in there. You need to read the Holy Bible once a day. If it's just one chapter a day, just read the Holy Bible. You need some mental health. You need some drug help, you need some alcohol help. You need a lot of help. I know you've been attacked spiritually. I already know that. I saw that when you were sitting over there the other day, you've been attacked spiritually. But you gotta ask God and Jesus Christ for help. You gotta ask God and Jesus Christ every day to help you and save your life. I know what's going on with you. You've been attacked spiritually every single day. But you gotta want to live that right life with God and Jesus Christ and Holy Spirit. The devil is attacking you for a reason. And he's trying to stop you from doing God's work. So my brother, hey man, like I said, you're my brother in Jesus Christ. We all brothers and sisters in Jesus Christ. All of us. And you gotta understand something. If you take somebody's life, you can't say sorry enough. I've already lost 2 sons. And this is my last living son. I don't want nothing to happen to him. I don't want nobody to do nothing to him, just like you wouldn't want nobody to do nothing to your children. I care for him. If he needed a part of my body, I would tell him, hey, cut me and take what you need and give it to him. This is my blood son. This is my last living son. I don't want nothing or nobody to mess with it. But you understand what I'm telling you, right?
All right. All right, sir. Thank you very much.
Yes, ma'am.
Thank you. Yeah, people get angry sometimes. All right, my understanding is some people are here for a docket today, but the docket was rescheduled. Yes, thank you. All right, who's here who believes they're on today's docket? Raise your hand. All right, sir, let's start you in the gray shirt. What's your name? All right, stand up, please. What's your name? Jimmy Montalvo. All right, just have a seat. Just give us a minute. And who else? What is your name, sir? I'm sorry? Parents Trevino? Okay. My allergies are not doing great this morning. All right, just have a seat. And who are you, sir? Luis who? I'm sorry, what did he say? Okay, thank you. All right, so your cases were rescheduled, but this is what we're gonna do. Step outside, call your attorney, and see if your attorney can come down here today, all right? So we're gonna start up a trial. Let's step outside, call your attorney, and let's see if your attorney can make it today, all right?
Thank you.
You're welcome. And then to the other person, Phoenix, and I'm sorry, Phoenix, what's your last name? Jones Miller. Your attorney said she's on her way. See it for those 4 people, if you can call their attorney, see if they're available. And then Lorraine Efren said she's on her way over.
Okay. Send everybody an email, Judge.
All right, and Deputy Laura, are you bringing out Mr. McIntyre?
Yes. But they're bringing them up.
All right.
And one of the judges right now.
Oh, okay.
Oh, there you go.
All righty. Okay, yes. All right, yes.
Sent you a second link, Judge. My sister couldn't hear the audio, so I fixed it.
All righty, the link keeps going down. I don't know why it does that. Who's out there shouting? Isn't it a little bit too early for Fiesta?
Never too early for Fiesta, dude.
Hmm,
It's never too early for Fiesta.
that's so true. But they say they're going to have, I hope my medals come in on time, but they're saying they're having a medal giveaway during the Pachanga. Am I pronouncing that correctly?
Yes.
That's gonna be terrible.
I used to say Pachanga, but people said
I call
no.
it Jenga.
Yeah. So they're saying they're giving it away. So we need to make sure that we are there to represent the 187th and get our medals.
I'll be on medal duty.
All right, I'm gonna make that happen. It says only one per person while supplies last.
Which pachanga is that you're on?
They started doing one every year that is between the two buildings. You know, the old courthouse and the new courthouse.
Okay, yes, that's it.
Because
Yes.
TCDLA does one. They used to do it for 35 years at our house.
Oh.
Christine's nixed that after. 30 years. It's now at Beethoven Hall.
Well, if I show up at your home, just know I'm there for pachinko.
A lot of people actually come
Yeah.
regardless, even though she puts the sign out. And
Well, usually I
one of
don't.
my friends follow instructions. Well,
Well, usually I don't celebrate Fiesta here because usually I'm with my mom for her birthday.
oh, well, happy birthday.
Oh, yeah. I will let her know you said that. But supposedly it starts at 11 a.m. So that means that we need to do by 10 a.m. And I think Deputy Laura, it was only last year that I discovered mangonadas.
Mangonadas
Oh my.
and chicken on a stick.
Okay, let me just tell you right now, nobody should be putting a chicken on a stick. I mean, doesn't a chicken already come with a bone in it? Why do you need it on a stick?
I don't get. It's like fried Oreos or something.
I remember the first time I went to Fiesta when I was in law school. I went to what is the New Orleans ones? What is the
Taste of your own.
Taste of New Orleans? And so I said, let me see if this is really tasting like New Orleans. I get there, somebody said, oh, we're going to have pork chop on a stick. And I'm like, how do you put a pork chop on a stick?
Reach out.
And let me just tell you, you can put a pork chop on a stick.
You put anything on the stick and fry it.
Okay, let me just tell you,
Right.
this is what I discovered. Maybe I shouldn't say it, but I'm gonna say it because I think it's the truth. In the town where I'm from, there was this great barbecue place called Silver Moon Barbecue. And as a treat, I would say like once a month, my mom and my grandmother, we could get barbecue from there, right? And everybody went there, and it was a hole in the wall place. Like you had the train tracks, and then behind it, this whole grassy area, and it was backed up, small place, best barbecue in the world. Well, when people would go to the clubs, not me or my family, you know, people are drinking.
Yeah.
They would end up with bad barbecue because they're not getting the fresh barbecue because they've been drinking.
Yeah.
We're happy. So my mom and grandmother would go and they would say, we want fresh barbecue. So at Fiesta, I see alcohol booths everywhere. So I just, you know, I'm just throwing that out there and tying that with the food.
Yeah.
That's what I was misunderstood. I thought you were in Auburn.
But I actually had agreed to work a booth when I was in law school. It was the pretzel booth.
Oh.
How hard can it be making pretzels? Oh, well, you know, I'm being all cute out there. I have on my shorts and the wind is blowing and all of the grass on St. Mary's campus has been destroyed.
Oh, yeah.
Have you ever had wind blowing and sand hitting your legs? Painful. And then some people were tipsy. One guy came to the booth.
Some people.
I'm just going to say some. A guy was tipsy. He came to the booth and I'm with my friend. And he told my friend he was going to go get his horse and, you know, grab her and ride off into the sun with sunset with her. And she's like, buddy, you're not taking me anywhere. But those were the days. And then we got up the next morning, the campus was destroyed.
Yeah.
When people see a trash can and it's full, there's, let's throw the trash on the ground. Yes. Oh, yes.
You put it on there.
And Norma, let them know it's gonna be Wednesday afternoon.
Just a minute. On Wednesday, so we asked for maybe set for Monday, so. they can do it.
Okay, sure. All right. All right, awesome.
Sorry, misunderstood your.
And then Norma, where's the attorney on? What is his name? Greg Wright? All right, Cindy, I'm gonna try the link you've given
Wait
to
a minute, I
me.
just sent you the final one. It wasn't opening for her. It has to start with ED and it wasn't, so. I've
All right,
fixed
I
it.
have it.
Now I've sent it.
When is an arrest?
No.
Maybe not.
Yeah, I can promise you we're gonna get to. start the jury this afternoon.
I was just asking if y'all, I mean, I was just saying, how many witnesses y'all?
I think we'll get, but we need to confirm something with.
Okay,
but
oh, I was
very long.
just for logistics for us.
And we're deciding whether we're gonna call he needs to make it out.
Okay.
And
Wait, call him.
he's.
This is true. I'm
Call
jumping the
who?
gun. I'm jumping the gun.
Y'all
And-
sitting
and
by
he's
phone
a-
line?
Well.
It's his
he-
decision.
he- Yeah, it's his decision and I wanted to think it, think it over. Now. We can, I mean, I know what. I really feel like it works, but we can go into. I know, by the way, it's been. By the way, he was there.
Great deal of
By
time.
the way,
Just making-
neither one of us has gotten any sleep and he was there until, right? 11:30.
Okay. I just-
Okay. And I think he understands.
Okay. Okay.
And you know,
Oh, yeah.
you.
I don't necessarily deal with people like how y'all have to, but I deal with others.
This, all of this will make for great sitcom or stand-up comedy.
Like I used to love that show.
Yeah.
And like the old one. I didn't watch the new one. I've recorded it, but I haven't had a chance to, but a lot of stuff.
Night Court's pretty good. Night Court.
Night Court. It's the original one.
Did you watch Jury Duty?
Which, no, I haven't.
Is that the one where one guy thinks it's real and everyone else
I
is in
got
on
it.
it?
That's,
God, it's so good.
that's just me.
Yes. Oh my God. It's like the worst nightmare of life. Like.
Ethics.
It's got.
Have
It's
you
got
had to run to the restroom?
Sure, yes.
Famous actor, but he's like a pianist actor. He's just like he get brought on as an alternate, but he keeps on trying to like force his way in and stuff, and everyone and he's like trying to be like, well, don't you like it's really good. And yeah.
That would be.
James Marsden. That's it.
Remember Jimmy Marsden. I went to his wedding.
Okay, Vashawn, you know what song was in my head this morning? Margaritaville.
All right, Judge.
Yes.
So now, and Vashawn, that's for somebody who doesn't even drink. But it just sounds like a good song, people just relaxing on the beach.
I'm gonna take a moment to confer with counsel
Sure.
and provide him with some of the promised things that I had mentioned.
But Vashawn, I have tasted tequila before. And you know what's so funny about it? People were trying to tell me how to do it. And they're saying, oh, you need to lick your hand. I'm like, that's unsanitary. Like, let me go wash my hands first.
I thought the liquor will kill the germ.
Oh, yeah, we should get.
And when we were in Scotland, you could go to different towns where they made, I guess they're known for their whiskey or scotch or whatever. And there's one town, I'm telling you, that entire town smelled like alcohol. And we're sitting there. I'm not going to tell the people who went because we were there for a international CLE. So I'm not going to mention any names, but we went to this distillery. And it was beautiful. The flowers were beautiful and everything. So they were passing out free drinks to everybody. And the people I was with there, they were saying, yes, Stephanie, we'll take that. I'm like, thank you very much, because it smells bad.
I mentioned. Okay, yeah.
But we were in Paris for CLE Bashan. And so money is flowing because it looks like play money. You don't even think of it as you're spending $300 a day, right? And so finally, we're sitting down to dinner and everybody has ordered their drinks. I was very fond of this drink that's sort of a lemon drink, but it's carbonated. And so they bring you these tiny glasses.
Yeah.
There's no medium, small, large, extra large. So I had ordered two. So the bill comes. And because everybody's spending $300 a day, money is starting to get tight. So we're sitting at the table dividing up the bill. And so
I'm sorry.
I say, whoever spent $40, the equivalent of $40 for drinks, you all need to pay your bill, right? And so we look at it and they say, Stephanie, that was you. Your two sodas were $40. Their wine, €2. And if only I were a drinker. But those were fun days. I've got to get back to Paris. All right, so we're just waiting for the jurors and waiting for your client.
Okay.
And they tell us it's a backlog, so. But Sean, have you started reading Fourth Wing?
I have not, Judge.
You have to.
I will. I just haven't had time to really.
I'm on book 2. It's called Iron Something, and my heart is racing because there's a lot of foreshadowing going on. Stop with the foreshadowing. So I'm like, yeah, it's called Iron Flame. Yes.
Check if I can have the Phoenix Jones Miller file brought down.
Yes.
It's here. Now what?
Lorraine Efron is supposed to be on her way here. And that way, so that person won't have to come back a second time since she's already here.
Yeah.
Thank you.
Yeah, all right, okay, thank you.
Where did she go? Did she go outside to call her attorney? Phoenix?
Ma'am, I'd be excused for a moment here.
Yes.
This is off the record, but I've talked to a client to able counsel. Whatever happens today, we're gonna be able to I think we'll be able to charge the jury today. So that-
No, we're not going to charge the jury today because I'd like for a jury to have full day of deliberations. So we'll charge the jury tomorrow.
After argument or before?
No, are you all calling witnesses?
That's what we're trying to decide. There are some issues with witnesses. I'll be happy to come back and go on the record.
Sure.
I want to be able to show the court that I wasn't making up this idea that there were photos on the cell phone. I did hear it from someplace and I want to show the court.
Oh, no.
I had a good faith basis for
No,
that.
no, I'm fine with
No,
that.
but I think the record, ultimately, there may be some lawyer grade in our paper.
Okay.
I'm not predicting what will happen.
Okay.
Also, we have, and I've provided to counsel, snippets that show
The basis for.
John, that John Hunter questions of the witness about Mr. Horace were made in good faith. He had a basis for that. And that witness, at least at this point, is unavailable. He was supposed to meet with us last night. I promised the prosecutor I would send him a summary of what the witness said.
Okay.
We now learn that there is a recording of what he said. Unfortunately, the witness has advised that he has retained counsel and he will not be available. He's going to invoke his Fifth Amendment.
Oh, well, who's the counsel he retained?
Pardon?
Who's the counsel he retained?
It's a civil lawyer in Houston named D, capital D, little E,
Well, have the
SIMON.
attorney appear by Zoom. And let's find out what's going on.
Well, we've been trying to contact him, but I can represent to the court as an officer of the court that I can't talk to him anymore, that I'm gonna assume that I think I have a right to rely upon his representation. He's gonna invoke his Fifth Amendment privilege. And therefore, I don't think we're in a position to offer the witness any longer. And as a consequence, and by the way, I'm gonna tender the court his name,
Okay, so,
his contact information, the
so let's do
lawyer's
it.
name, and I'm giving this to counsel.
all right,
the
so
lawyer-
let's do this.
Can I go to the bathroom?
Yes, yes, and we'll wait for your client to come out so we can have everything on the record.
And then we need to talk to him,
Okay,
obviously, about what he wants to do.
okay.
There
All right,
may,
and I'll give you all a chance to talk to him.
okay, because that will depend on how many witnesses we have, if any.
Okay.
I'll be right back.
All right.
I approach the court.
Yes.
Just hold up your finger.
Let
Thank you so
me
much.
look.
I got you.
think y'all marked some exhibits yesterday, but you didn't give them to, because they didn't come in. So I know, I haven't seen through number 9, but I know you marked 10 and 11. Okay. But they never came in. So I think you're on 12. Yeah. I'm gonna look at one more place.
Thank you so much. I'm sorry to.
All right, I see, the last thing I see, Jerry is a defense 5. Everything else, I think, was for the record.
There's a 9 that came in.
There's a 9?
It's
Okay.
that,
And I believe there may be 2 exhibits that were not offered or and we're trying to.
this is the 9, Judge, it's the,
Ah,
that
So
transcript.
this would be 10.
No, I know he marked a 10 yesterday, just can't. But it never came to me. I was gonna,
Comes back around.
Yeah, 'cause
I'm
we
gonna
left too
make
soon
sure
yesterday.
that's fine and we'll start them. These are matters, Your Honor, for the record,
mm-hmm,
out of the presence of the jury
okay.
with respect to the witness who has invoked his Fifth Amendment privilege. And I have asked Joanna Collins, our investigator, licensed investigator. She's in the courtroom.
Okay.
The only reason she would testify is if there's some question of what was said.
Mm-hmm.
But I'm gonna represent that to an officer, as an officer of the court. If the state wants to call her, they can. But she's been in the courtroom before, so
Okay.
she.
And what is the update on their client being brought? Right, what's the update on Mr. McIntyre being brought?
I'm still waiting for him to be transferred.
What is going on at the Bear County Jail?
Welcome, by the way, at least you don't have to wait a couple of hours on a Sunday, like John and I did, 2 Sundays. in a row.
Okay,
So
all
I
right,
hope they can't come here.
all right, thank you. I don't know what's happening.
He said it was the bailiff in the 187th who caused the problem.
Hey, we don't we don't cause problems here, we solve problems. Let me speak to you in the back. All right, so everyone, I just let the jurors know that we were running behind schedule and it wasn't due to any actions of the state or the defense. And I informed them that it has something to do with the building. And technically it does, because it has to do with transportation to the building. And so I let them know that throughout the courthouse, there's an issue with the building. I just didn't tell them it was transportation to the building. So the court is calling 2019 CR 12495 State versus Tamar Mcintyre. Can I have parties announced for the record?
Jason Garrett and Megan Galloway for the state bar.
John Hunter, Jerry Goldstein, Thomas Lane for Mr. McIntyre. He's present, Your Honor.
All right. So I believe there was something defense you wanted to put on the record.
Yes, Your Honor, but I believe we need to briefly confer with Mr. McIntyre, if that's okay.
Yes. So state, if you would just go in the back or either go in the back of the courtroom so that they can confer with their client.
Yes, Your Honor.
And to the media that's present, just make sure you're not recording their conversations. Mhm. Okay. Okay. That my metals are making its way through custom. Tomorrow, but they'll be here before Fiesta. Could someone let the state know? Thank you.
And then we have those preliminary minutes.
Okay. Yes, and then if your client will sign the reset form. Thank you.
Yeah.
Oh my gosh, baby dragon is doing well, right? All right, we're back on the record and defense, you stated there's something you would like to put on the record.
Yes, Your Honor.
All right, you may proceed.
Thank you, Your Honor. If I may put for my seat.
Yes.
The court probably recalls the cross-examination, the able cross-examination by John Hunter of the state's witness, Joanna Reyes,
Mhm.
where he inquired of certain statements that she made and the name, Rashard, Rashard, Horace, Horace. To him, a boyfriend that she lived with for a period of time, I think a 1 month and a half in Houston, and was dating here in San Antonio. In that regard, the witness was supposed to arrive in San Antonio, told our investigator, Joanna Collins, who is in the courtroom, and she has been previously. She's a licensed investigator, and she's been working on this case with us for over 5 years. And I would represent to the court as an officer of this court that the witness, Rashard Horace, who had promised or indicated to us that he would be in San Antonio, meet with her at my offices here in San Antonio at 4:30. Late last night, I believe it was after 7 p.m., he contacted Miss Collins, our investigator, and advised her that he had retained counsel, and that he was not going to testify. He was going to invoke his Fifth Amendment privilege. Based upon that, we were confronted with several issues. One, I believe under the Texas Code of Professional Ethics, rules of professional ethics, I believe it would be improper for us to continue to talk to him once he advised us that he had retained counsel. Secondly, it would be improper for us, I believe the law is clear, to call him as a witness to invoke his Fifth Amendment privilege in front of the jury. I know I would object to that at the state. Given those facts, we have been unable to reach his counsel, and I provided the state with, and I would offer to the court what has been marked as Exhibit 12. I would advise the court that Exhibit 11, which has also been tendered to the state, and I believe one of the able counsel has listened to it. Ms. Collins advises that she didn't realize that when they called her office instead of her cell phone, that there was a recording. And so we have a recording of her conversation with him, which is important for purposes just of the record, not before the jury. But I would offer defendants Exhibit 11, which is the recording of the conversation between Joanna Collins, the licensed investigator, and Mr. Horace. And I have tendered it to counsel, and I would offer that solely for purposes of the record.
All right, so if you could label that so there's no confusion, D11R and D12R. Just add the letter R.
Defense 11R
Yes.
and defense Exhibit 12R, which I've also tendered to counsel, is the name Richard Horace and his telephone number, which we are not calling because he's represented by counsel, and his attorney, which he advised us of, Donald D. Simone, D, small d, little e, capital SIOMONE, with his telephone number. We attempted to reach the attorney last night. Did we call him again today?
No, I left a voicemail at both my cell phone and yours.
We
Jerry,
have not heard
disclose.
back from them, but as an officer of the court, I don't think I can move forward when somebody is advised that they've got counsel and they're looking. As a consequence, we will not be offering the witness But we wanted the record to adequately reflect what I think shows good faith. First, I have what's been marked as Defendant's Exhibit 13R, which is an excerpt which I provided to council sometime earlier today, I think, maybe an hour. And I had made a statement to the court with respect to the alleged child pornography. And I said it was on a cell phone, and I was corrected. I knew I saw it someplace. It is in the recording, and I would tender and ask that it be admitted for the record purposes only, 13R, Your Honor, in which the witness, potential witness, Mr. Horace, tells our investigator
Oh, and
that-
counsel, with regards to that, because the court is aware that there are certain connotations with regards to any offense of that nature. If you just want to admit it into the record, it's in the record.
All right, just, I wanted the court to know that I was making a good faith.
No, I appreciate that.
About what I thought.
All right.
Well, the statement on 2 counts. One, when I said that I was in error, when I said it, now I withdraw that. I want to show the court why I said it. Secondly, Your Honor, I would offer defendant's exhibit number 14R. And it is, Your Honor, it is the excerpt that show the basis for the specific questions that Mr. Hunter asked of the witness, Joanna Reyes, the state witness. And it's being offered for the purposes of demonstrating that he had a good faith basis for asking those questions. We anticipating that we would have the witness, which we do not. We're not asking this to be presented to the jury, but I think it is important that the court knew that we didn't make that about the whole point.
Okay, so I will tell both parties in looking at 13R. So they're saying that some pictures were found inside a camera. Were there pictures found inside of a camera?
No. In fact,
camera
the
was
camera
never
was
found.
never recovered.
Well, by the way,
They say
So-
we're cell phone.
It says cell phone,
All right, so,
and that's
With
what
re-
I said.
all right, so with regards to defense 13R, nothing was ever taken from the cell phone. So it appears that if somebody was saying that there was something in a cell phone, I don't know if that was interrogation techniques or what, but do both parties agree that there was nothing, no photos pulled from the
We have
complainant?
no idea. It was never done.
No, there's no evidence of that, Your Honor.
That there is no evidence because nobody was able to look. Now, it's offered not for the purpose of the truth of the matter, but to show why able counsel asked those questions, because we expected that witness to say that that's what she said, which
Alright.
was contrary to her testimony.
Well, and if
Yes.
I can respond to that, because I've listened to the recording and what is alleged is that the state told the witness that illicit material was found, which is wholly untrue.
But by the way,
So
we're
That's
not,
not really. a
we're
fair
not offering it for the
characterization.
truth.
All right,
We're just offering it to show the good faith basis for the question.
okay, so this is, we're gonna have one person at a time.
I'm sorry. Your Honor.
I'm listening to everything. So I have some questions and then we can talk about defense's exhibits. Are there any other exhibits, defense?
Yes, Your Honor, there is, I believe it's 14R, which is the basis for Mr. Hunter's questions. If you're still speaking about the photographs on the cell phone, which is, I think, what counsel was alluding to.
Okay, so the only evidence that you are offering in for the record is 12R, 13R, 14R, and what is the?
11R.
And 11R, is that correct?
11R is the total recording, Your Honor, which has
Okay.
been provided to the state.
All right, so anything else that's being offered into evidence for the record?
Yes, Your Honor. The basis for Mr. Hunter's questions.
No, I mean, do you have any other exhibits to be offered into the record?
No.
All right, so, oh, and counsel, you can remain seated. It makes it easy for the court reporter to hear. So I want to take these matters one at a time. All right, with regard to this witness, Mr. Horace, was he subpoenaed?
No, Your Honor, we didn't learn about him until he called Mr. Hunter night before last, emailed him. And Mr. Hunter appropriately said, I can't speak to you. I'd like you to speak to our investigator. And that's when the conversation the next day happened between Miss Joanna Collins and the witness.
All right, and I'm assuming the email contained information that you thought would be relevant to this case.
No, the email that we're talking about, that he said I've retained counsel.
Your Honor, just to clarify,
Yes.
the email contained a photograph of Mr. Horace with Ms. Reyes, which was tendered to the witness as defendants 10. And we asked the witness to identify the individuals depicted in the photograph, and I believe the witness testified that that was her ex-boyfriend and her. And he indicated that he had information about the case, and that's why we directed him to our investigator.
All right, and so what date was this? That
Day
he,
before yesterday.
so we're saying this was Tuesday?
The initial contact was made on the 8th.
Okay,
And understand that we're not offering this to put it into evidence. We're offering it to show the good faith nature of his question.
so, all right, so I understand that. So then you all had no intention of calling him as a witness?
We did.
Well, but we would love to, but he has advised us that he's invoking his Fifth
So,
Amendment privilege.
well,
And
this
what
is,
I'm advising the court is that we're gonna honor that. And since we can't contact him directly, unless the court wants to continue this case and
no,
not.
let's call the attorney. It appears,
We've been trying, Your Honor, if the court wants to try.
all right, just give me a moment.
Sure.
And I'm assuming it's this law office that handles civil So what I have done, and there was no objections from the state or the defense, I've informed the jurors that we will start at 2. That will give us some more time to make sure everyone has what they need. So the court has in evidence for the record Defense Exhibit 11 for the R, Defense Exhibit 12R, Defense Exhibit 13R, and Defense Exhibit 14R. And both the state and the defense went to chambers with the court. Neither party had an objection to the court reaching out to the attorney. Is that correct, both sides?
Correct, Your Honor.
Correct, Your Honor.
All right. The court did leave a message. My understanding, that attorney is in depositions. Their depositions started at 10. They anticipate the depositions will be over with by 11. And one thing I can say about the civil side, when they do time announcements, their time announcements are exactly their time announcements. If they say it's going to be an hour, it's an hour, it's not more.
That's fine.
So with regards to the defense exhibits, I don't know if y'all want to wait and come back at 1:30. I'm telling the jury to be back at 2. So at 1:30, we can see what the results of are with the attorney and with your potential witness.
That's fine, Your Honor, and we'll be at, I'm not gonna go anywhere, so I will be here in case they call back. We can do what the court suggests. I'll have my counsel. I would like to advise the court that when all this is over, so you have some idea where we're going. All we're offering it is to show that we made, that it was a good faith, those were good faith questions. I don't think that's gonna be an issue. The second thing is whether the state has the opportunity. This just relates to the question, other than the one with respect to the photo, to the questions that Mr. Hunter asked. I am asking the court to consider when this is all over with, if we don't have a witness, that the state not be allowed to argue or infer that we were somehow dilatory or not being honest in asking those questions and not having a good faith basis for them. If that's the case, I believe I'm being made a witness in this case, and I'm gonna have to move to withdraw.
All right. So what I can say is with regards to Defense Exhibit 13R, it appears that this is some sort of hearsay within hearsay, because it's saying that it's alleged that the witness is saying that a district attorney and a private investigator told her something. And it's not a statement it doesn't appear that it's a statement that she made.
No, that's with regard only to the photos, and that's not the issue. The issue is with respect to the questions that Mr. Hunter asked. The photos didn't come in, and the court admonished the jury at length, and as opposed to our instruction, she admonished them at length not to consider it. I just wanted to show that I had a reason to believe that I said it was on the phone. What we're talking about is the questions that Mr. Hunter asked, and we used his name because we thought he would be here, and I believe we're entitled to, since the witness denied it, and we don't have a witness to rebut it. All we were offering the statements for is her statements that are exactly contrary and mutually exclusive with what she testified on cross. And if all I'm saying is Mr. Hunter had a good faith reason to ask those questions, and we shouldn't be put in a position of, if we're doing it in good faith, making it look like we didn't make any efforts to produce the witness. We're availing ourselves of the able courts process. If we can get it, great, but otherwise I don't think we should be made to look like we didn't offer. There were witnesses that they said are out of the country they can't get, who were material. She was the head and senior CSI officer. Can we argue that they are responsible for her not appearing? I'm just saying that.
I think legally you can argue that she didn't appear.
Okay, I understand that. I'm concerned that
Your Honor, if I.
that it's going to look like us, and it deals with our credibility, that we misrepresented the fact that he said that. And since they're not gonna be able to see that he did say that to us, I wanted to be sure the court knew we had a good faith reason for it. And I don't think that we should be punished for that. I think we followed the ethical rules, and I think it puts my credibility and Mr. Hunter's credibility and ethical consideration. We got the wife of a very well-known lawyer in this town on that jury. I don't want my credibility or my ethics to be put in, and I think they've created a problem for me. All I'm saying is, as long as they don't say that, look, they asked those questions about this guy and he didn't show up. He's entitled, if he's gonna invoke his Fifth Amendment privilege, let's have him invoke it before the jury.
And Your Honor, just very briefly, if I can add a little addendum to what Mr. Goldstein says, and this can be discussed more at the charge conference. What I think Mr. Goldstein is urging is that there would be limitations on what the prosecutor would be entitled to argue based upon that portion of Ms. Reyes's testimony, in the sense, but that there is a curative instruction that would be perfectly reasonable, that would apply to both sides, that can be given, which is to simply instruct the jury on the function and the purpose of Rule 613 in the charge, and to explain. You have heard statements in the course of this trial that are attributed to witnesses, some of which were adopted and agreed upon, and some of which were denied. You are to understand that any such statement is not being offered for its truth, but merely to confront the witness about whether or not they said it. And it is to be considered by you only in determining whether or not you find the witness credible.
I'm not putting that in a jury charge. Here's the thing. You all question witnesses. You all make your objections. I make a ruling on those objections. The jury, I don't believe, is thinking, oh my gosh, is the defense or is the state saying something that is untrue? The only thing they know is an objection was made and the court ruled on the objection. Either I sustained it or either I overruled it. I don't see how 613 comes to play in the jury charge. And I think we're moving far afield of defense's exhibit state.
I believe we're entitled, and I would re-urge now, and I will, if the witness testifies, we don't have to worry about it.
All right, let's cross that bridge when we get to it. Because
I'm happy to wait. I just want to give the court notice, and I want counsel to know that if the witness is not going to testify, that we made our reasonable efforts and fulfilled our ethical obligations to our client. And I believe that puts my credibility in issue and John Hunter's credibility. And I'm going to move to withdraw. I'm not going to have that jury have the idea that somehow I'm engaged in chicanery.
It would be, what we're discussing, Your Honor, would be the issue of, while the prosecutor is well within their right to say that those statements were offered.
Okay, here's the thing. You all are talking about a jury charge. We're not at a jury charge state yet. The only thing we're at right now is, do you have any witnesses? It appears that you wanted a witness here. That witness is stating that they've retained an attorney. You all have tried to reach the attorney. You all have agreed that the court could reach out to the attorney. I'm telling you, the attorney is in depositions, started at 10 a.m. I'm being told that those depositions should probably last for close to an hour. I left them my cell number. They're going to Zoom in. When they can Zoom in, you all will have a chance to speak with them. But so both parties are aware, and this was an assistant. I'm assuming it's the assistant to the attorney, which it's hearsay, double hearsay. But she says they do not represent him in anything other than a civil matter. Has to do with an accident.
Have a conversation with Mr. Hart.
Yeah. So that's all we're doing. We're not arguing the jury charge, what comes in, what stays out.
And the real question is whether he's doing it on advice. If it's not on advice of counsel, then I'm entitled to talk to him.
Well, we're
And-
gonna
and-
find out.
And more importantly, Your Honor, regardless of that, I want to talk to him. But if he invokes his Fifth Amendment privilege, that ends my ability to deal with him unless the court wants to challenge whether he has that right. I'm happy if the court instructs me to, if he calls back and he invokes his Fifth Amendment privilege, to have him testify before the jury, question by question. And he
Yeah,
can-
what will end up happening, if you think he's gonna invoke his Fifth Amendment rights on every question, then we can have a hearing outside the presence of the jury and see if that's the case. So other than this witness, maybe, are there any other witnesses?
It would depend on whether that witness testifies, but I can assure the court it would be short and that we're not gonna have more than an hour and a half to maximum 2 hours of testimony or at the max.
All right, then state your response.
Regarding defense exhibits 11 through 14R, I take issue with the fact, good faith argument, okay, because the question that was asked by Mr. Hunter to the witness, Joanna Reyes, was, did you tell Mr. Horace that you personally observed child pornography on the camera?
But that's not the one that we're
Well, no,
talking
no,
about.
so, all right, so, both parties. I will allow both sides to put ever what they want to put in the record. So, once the state's finished, then defense, if you have some response, you can respond. State wants the defense response. If you have some response, then you can respond. So state.
The witness denied that because the witness never told that to Mr. Horace, and
Well-
he in fact did, let me finish. In the recording that was provided to me by defense counsel, Mr. Horace explicitly states that Ms. Reyes told him that the state told her that they looked in the phone and there was some examination on a cell phone and that there was child pornography. That is absolutely not true. The phone was never examined and there is no evidence at all of the child pornography. And so at the time, it's untimely now, but it was improper impeachment by Mr. Hunter that I couldn't object to because I was just provided this recording this morning. And so that's what I want the record to reflect.
And if I may respond to that, Your Honor, since that issue is directly pertaining to my question. As Mr. Goldstein explained, we did not have the benefit of the recording when the questioning was done. I had the benefit only of rough notes from the investigator. Secondly, I think that the prosecutor's argument misapprehends the basis of Rule 613, and we've made that record as explicit as we can. And I understand that there's disagreement, but we stand on our papers.
Then it's not offered for the truth, Your Honor. It simply was offered to show a prior inconsistent statement. And that all I'm interested in,
Well, no, because from what I'm reading
yes,
is that according to the video that you all have given the state access to,
it's
And
an
that's
audio,
been-
Your Honor.
and that's audio,
It's an audio.
all right, the audio and that what's been admitted for purposes of the record, I guess it's D11R.
It's the 11R.
All right, so in it, according to what's been transcribed, the witness never said that she saw the illicit material. She's saying that a district attorney and a private investigator pulled her in the room and said, this is what we saw.
Which we didn't have the recording
No,
at the time that so.
and I understand that. And what I'm telling you both is I am not saying that either party has done something untoward. I'm not
The
saying
state
that.
has. I mean, that's the implication of what
No,
legal
what
counsel
she's-
is saying, is that we have done something.
All right, so here's the thing. All of you all are attorneys. I don't think anyone is going to do a closing arguments and say these attorneys are unethical. It's not allowed. State, do you have any intention in your closing argument, and I don't want to go into great detail, of saying that these attorneys are unethical?
It's not allowed, but it's evidence, Your Honor, so I intend to fight.
So that would be a no. So I don't understand why we keep going about being unethical and whether or not a jury thinks we're unethical, because you all make objections, both sides. I make my rulings on those objections, the end.
Well, no, if an argument's gonna be made that we failed to call the witness, then we're gonna ask to reopen. And if we're not allowed to, I think it does imply that we did something in terms of not calling the witness. And if the witness insists on their Fifth Amendment privilege, I think that puts us in a bind, an ethical bind. And I'm simply not gonna have this jury believe that I did something like that.
You're not the person who even asked the question. Your co-counsel, is your co-counsel going to withdraw because the jury will think that he did something unethical? Because your co-counsel is the one who was cross-examining the witness about, what the witness may have said. So if someone is saying that they're going to fall on their sword and withdraw, then it wouldn't be you. You didn't ask the question.
Well,
And
just like the prosecutors.
Hold on. There are two issues at play. The first is that the implication of what able counsel for the state just remarked about is, I think, plainly an indication to the court of a plan to strike at the defendants over the shoulders of counsel. And secondly, the way in which this process is going forward is attempting to drive a wedge of conflict between the defendant and his counsel, which is an issue under Strickland versus Washington. And it is a problem that has deeper implications.
All right, so let me give you all the deepest implications in this case. You all ask questions, people make objections. I rule on those objections. And you all can accept my rulings or not. But what I am telling you is, one, I expect everybody to follow the rules of evidence. I expect everybody to follow the rules of professional conduct. And if you don't follow the rules of professional conduct or the rules of evidence, that's where I step in. Now, if somebody believes that there's a wedge between them and their client, then file a motion. We are not here at this juncture to talk about the charge and what will be in the charge and the arguments that people can and cannot make. If you all want something specifically, and this goes for the state or the defense, that somebody is not allowed to argue, then file a motion. That's what I can tell you. That's the way it should be done.
We will do so. Thank you.
Now, other than this witness who may or may not appear and may or may not be available, are there any other witnesses?
There is before the court, and I believe it's been marked as 14, Your Honor.
14R?
14R, D 14R.
Yes.
It is that clip from an Instagram from a Miranda Hubbard. I will tell you that it was at it's YouTube, Your Honor. And I'm not sure this came. Can you tell that from this? Anyway, it is before the court. Counsel has a copy of it.
I don't have a copy of it. What is
Well,
it?
it's in that, I put it, I offered.
Was that not yet? Which one?
It is marked.
It's marked, but you haven't given it to the judge.
I believe we have. Yeah, can we?
No, I
All
only
right.
have
14R.
12,
It is
13, and
14R,
15.
Your Honor.
No, what was that?
That would be 15R.
No,
You gave it.
let me see, may I see 14R, Your Honor?
Sure.
Right, then this is 15R, thank you.
And I'm sorry, let's go off the record for a moment.
Thanks for calling the phone law.
on the record with respect to defendants exhibit 15R.
All right, what is defendants 15R?
That is the.
We're
And
not done, state. Sorry.
sorry,
I thought we were done, but.
I know.
No, no problem.
He called when we were. This is the reply. Is this YouTube?
I believe it's YouTube, but.
It
you saw
appears to
it.
be YouTube.
Let me see.
And this, the first page of is a cumulative exhibit D 15R is the comment that was on it. The second is the.
Okay, may I see
person that
the-
made it. I just want the record to reflect what we're getting.
Okay.
And the last is a list of calls. The first five, Ms. Collins, who is listening, and she can correct me if I'm wrong. She called last night. The rest of them, she's either called and she went by residents that are connected to this woman. as well.
Sure, no problem.
Thank you. This is all about it. This is all about it.
So none of those are admitted, Judge, right? They're just.
Being to look at lawyer, if I just blew it off. When somebody said, "Oh,
All right, so are you telling the court that this is the person you want to call as a witness?
If we can reach her, Your Honor, we're still trying.
You've seen it, Judge.
They've got a copy of it.
All right. Is there anything else?
We're still trying to reach her, Your Honor. The court asked us, did we have any other witnesses? I wanted to show the court what we're trying to do because I got an email last night at, I think it was 11 o'clock, telling me to, hey, you ought to look at this thing because I don't read those comments.
All right, well, it says here that the witness is a cashier, so everybody knows where she's employed. Just go subpoena her.
Do we know, can I ask?
I mean, no, that's what it says on the exhibit that you gave me.
Well, that's what she said, not what I'm saying. Can I find out whether perhaps we've already explored that? May I ask the?
Sure, but what we're gonna do is we're taking our recess now. You all need to be back here at 1:30.
Sir.
All right.